Hello. Thank you for joining us for Juristconsult Chamber's first webinar on employment law. I am Burty Francois, Senior Associate at the firm, together with Khemila Narraidoo, Barrister at Juristconsult Chambers. The Mauritius financial sector has been blooming over the years, and as a result of same, we have had numerous calls to bring on more substance to global business companies set up in Mauritius, which are investing in Africa or Asia. One of the ways to show added substance has been through the employment of personnel who work either in Mauritius or in foreign jurisdiction with a Mauritian law governed contract of employment. The focus of this webinar today shall be twofold. Firstly, foreigners coming to work in Mauritius, and secondly, persons working in foreign jurisdictions under a contract of employment with a Mauritian entity. My colleague Khemila Narraidoo shall now be highlighting the important features in relation to non-citizens working in Mauritius.
Indeed, as Burty has mentioned, with its unique geographical location combined with a rich history, right in the cradle of different cultures, Mauritius has been attracting a lot of foreigners and is considered to be a privileged place to work and live. The success of Mauritius as an ideal platform to set up global business companies has given rise to a number of issues in the field of employment law. The issues that I shall be dealing with relate to a foreign employee coming to work and live in Mauritius. A foreign employee has the duty to take cognizance and understand the various laws that govern employment relations prior to coming to Mauritius. The main legislations applicable to foreign workers are the Immigration Act and the Employment Rights Act. The Ministry of Labour, Industrial Relations and Employment and Training is the authority responsible for the subject of labour and employment relations in Mauritius. Another authority is the Board of Investment, which is responsible for issuing occupation permit in Mauritius, which we will see in more details during this webcast. Also, the relevant court, which deals with disputes in the employment law area, is the Industrial Court in Mauritius. For foreigners who wish to come and work in Mauritius as an employee, the first step to look into by the foreigner is the permit. This can be by way of either an occupation permit or a work permit. Let's look first of all at an occupation permit. An occupation permit allows a non-citizen to live and work in Mauritius. It consists of both a work and residence permit. An occupation permit is normally granted into three categories only, namely investor, professional, and thirdly, self-employed. Since we are here to look mainly into the issues which relate to the contract of employment of a foreign employee, we shall focus on the occupation permit for a professional. As per the Immigration Act, a professional is defined as an expatriate who is employed by a company incorporated in Mauritius to deliver professional services. The occupation permit for a professional is designed for applicants who are willing to settle in Mauritius and work as professionals. The main criteria to be eligible for professional occupation permit is that the foreign employee's salary should exceed 60,000 Mauritian rupees per month. In case the professional is in the information and communication technology sector in Mauritius, then his basic salary should only be in excess of 30,000 Mauritian rupees. Upon sending his application, the professional would be required to send all the original copies of the list of documents which one can find on the website of the Board of Investment. Applications for occupation permits or residence permit are made through the Board of Investment, commonly known as the BOI, to the Passport and Immigration Office of Mauritius. The BOI and the Passport and Immigration Office jointly operate the Occupation Permit Unit, which facilitates the issuance of occupation and residence permits to foreign investors, self-employed individuals, and professionals within 5 working days. The point to be noted is that you can actually apply online. The list, which will now be shown on the screen, contains the list of documents which you would need to send along with your application form. The documents differ depending on whether it is the first application or a renewal. Once the occupation permit application is submitted, the delay of response is normally within 2 weeks when the application is filed at the Board of Investment and approximately 2 days when the application is made online. It is important to note that an occupation permit is not transferable in respect of business activities that it has been registered for. In case of a professional, he or she is not allowed to change employer and remain on the same occupation permit. The interesting thing to note about the occupation permit is that it enables the dependents of an occupation permit holder to also apply for a residence permit. By dependents, here we mean spouse and children. Children would include step-children or lawfully adopted children under 24 years old. Should the dependents want to work in Mauritius as well, they would have to apply either for a work or occupation permit, as the case may be. Unmarried partners are eligible for the application as dependent for a 6 months residence permit only, which is renewable thereafter. For a professional who has been granted an occupation permit as a professional, if he is earning more than $3,000 per month, then the foreign employee is eligible to purchase one apartment in a building of at least 2 floors above ground, but this must be solely for his personal residence. Interestingly enough, a professional is also allowed to apply for a short-term occupation permit, which will authorize him to work and live in Mauritius for a period not exceeding 9 months. However, this permit can be renewed once for a period not exceeding 3 months. As a holder of an occupation or residence permit, a foreign national is eligible to apply for a 10-year residence permit, provided that as a professional, his basic monthly salary exceeds 150,000 Mauritian rupees for 3 consecutive years. Having covered the application for occupation permit, we shall now look into the application for a work permit. For those expatriates who are not eligible for an occupation permit, an application for work and residence permit should be submitted to the Ministry of Labour, Industrial Relations, Employment and Training, and to the Passport and Immigration Office. Work permits in respect of non-citizens are issued by the Employment Division of the Ministry of Labour, Industrial Relations, Employment and Training under the Non-Citizens Employment Restriction Act 1973, which provides, among others, that, I quote, "A non-citizen shall not engage in any occupation in Mauritius for reward or profit or be employed in Mauritius unless there is in force in relation to him a valid work permit." The Act also provides that, I quote, "that no person shall have a non-citizen in his employment in Mauritius without there being in force a valid permit in relation to that employment." Therefore, as you can see, the law affects both the employer and the employee, and both of them should be concerned with the work permit. An expatriate who wants to work and live in Mauritius under a work permit must meet the following 2 criteria to be eligible for a work permit. Firstly, foreign workers should normally be aged between 20 and 60 years. Departure from this policy is exceptionally made for investors and expatriates who are above 60 years old and who possess specific expertise. Secondly, foreign workers should possess the skills, qualifications, and experience required for the job applied for. Application for work permits may be submitted for either, firstly, individual, in managerial, supervisory, technical, and professional grades, or in bulk for skilled workers once the quota has been granted. I hope this summary has enlightened you about the formalities to be followed for foreigners who wish to come and work and live in Mauritius. My colleague Burty will now tackle the issue of employees working in a foreign jurisdiction under contract of employment with a Mauritian entity.
We are here in a situation where someone works in X country and that person's employer is a Mauritian entity. In the case of an employee working outside Mauritius, but under a contract of employment with a Mauritian entity, the issue will be to ascertain the applicable law. That is, will the person's employment be governed by that country's employment law or by Mauritian employment law? This is an important issue because, as we're going to see, this can have important consequences on the relationship between the employer and the employee. We shall analyze briefly three main examples of sale. Firstly, if the employee's contract is terminated, it might prove advantageous for the employee to claim severance allowance in that country as opposed to the computation of same under Mauritian laws. An employer will not take the risk to allow the employee to go and choose the applicable law that will entail greater liability for it. Second, same will apply to disciplinary proceedings. Under Mauritian laws, misconduct is a ground for the dismissal of an employee and is defined under our employment law, that is, the Employment Rights Act. However, in the scenario of a conflict of laws, the act of an employee may qualify as an act of misconduct under the ERA, but not in a country where the employee is working. This again will entail greater liability for the employer should the latter elect to dismiss such employee. Last, an example will be the general conditions of employment. This could range from the maximum number of working hours to the number of leaves granted or even to retirement gratuity. These are important elements which the Mauritian employer need to foresee in order to mitigate risk from the claims of such employees. It is a positive to note that there are no recent judicial decisions in Mauritius with regards to that precise issue. The most relevant case will be the case of Permanent Secretary Ministry of Labour and Rogers & Company Limited, 1965 case. The issue in that case was whether an employee working in Diego Garcia, which was then considered as a lesser dependency, under a contract of employment with Rogers, a Mauritian entity, was to be governed by the then applicable labour ordinance. The approach taken by the court was that, in the absence of any laws or regulation in relation to contracts of employment, the object of which is meant to be carried out outside Mauritius, we need to rely on the general principles of private international law as regards to conflict of laws. From the perusal of the authorities on private international laws, dices, conflict of laws, and Encyclopédie d'Alloz, amongst others, three main principles stand out. Firstly, the choice of the parties in a contract. If both parties, that is, the employer and the employee, have expressly provided that any relocation or secondment shall be subject to Mauritian laws, then the will of the parties shall prevail. Both parties shall then have all rights and obligations as if the contract was being performed in Mauritius. Secondly, where the contract of employment contains only the standard clause as regards to the applicable law, that is, simply stating that the contract shall be governed by Mauritian law, with no mention of location or secondment, or where there is no applicable law clause at all, the proper law of the contract may be presumed to be the law of the country where the performance of the contract is to take place. I quote, "Great weight will thus be given to the law of the place of performance as being the proper law of the contract, especially where the contract is made in one country, but to be wholly performed in another." The presumption is here very much stronger, because the contract is almost certain to be far more closely connected with the place of performance than the place of contracting. Thirdly and lastly, one should not forget that the ultimate goal of employment law is to protect the employee, since it is generally accepted that the employee does not sit at arm's length with the employer. Therefore, when applying a rule of interpretation, a judge may decide that the applicable law shall be the law which will afford more protection to the employee. As you will have gathered, there is no hard and fast rule to this issue, and cases will generally be decided on to the merits of each and every case. This is precisely why we should not wait for a problem to arise to decide on the applicable law, and we will therefore advise employers to implement the following practical points in order to limit their liability. 1. When an employee is due to leave Mauritius, the parties should already agree on the applicable law by way of a secondment or relocation agreement. 2. The employer may provide for the temporary suspension of the original contract of employment or consider validly terminating the first contract of employment prior to the secondment or relocation. Third, provide that, in the event of termination, The employee shall waive potential claims that the employee may have in other jurisdictions.
This is it for today's webcast. We hope that you have enjoyed it. I'm sure there will be more opportunities to discuss employment law and its challenges during the course of this year, and we'll be more than happy to discuss them with you.